Hello everyone, and welcome to the first of our video tutorials on criminal process sentencing. Sentencing is quite a large topic, so I've summarised on this slide what you need to know about it. Firstly, you need to know the aims of sentencing. So this is what the judge is trying to achieve with the sentence that he gives. You need to know the different types of sentence that are available to the court. And you need to know what factors will be taken into account when the judge sentences the defendant. In today's tutorial, we're focusing on the aims of sentencing. And you can see here that the Criminal Justice Act 2003, section 142, lists the aims of sentencing as retribution, deterrence, rehabilitation, incapacitation, and reparation. And we're going to have a look at each of these in turn. Firstly then, retribution or retributive justice is a theory of punishment that when an offender breaks the law, justice requires that he or she suffers in return. And it also requires that the response to a crime is proportionate to the offence. Retribution is often closely associated with revenge, but there is a distinction between them. They are both concerned with directing justice at wrongs, but retribution involves no pleasure at the suffering of others. It's simply focused on, you've committed a wrong, so now you will suffer in proportion to that wrong. The concept of retribution is found in most world cultures, many ancient texts. You can see in the law of Moses, an eye for an eye, a tooth for a tooth, a life for a life. And this is sort of the ancient justification for retribution. And it's this idea that was justification for the death penalty. There are some places in the world where the death penalty is still legal, but obviously not here anymore. But when we did have the death penalty, the justification for it was retribution and this idea of a life for a life. Hopefully you can see it's quite an old-fashioned concept. It's not really forward-looking. It's very difficult to take the moral high ground as a state and say, what you've done is the worst crime ever, murder, it's awful, so we're going to respond by killing you. It's just illogical. It's a flawed argument. And that sort of led Gandhi, this is a famous quote from him, he said, an eye for an eye and we'd all be blind. So pointing out one of the big flaws with the idea of retribution. It's quite old-fashioned, it's backward-looking, it is focused on the wrong. And as you can see here, it doesn't seek to reduce crime, it doesn't seek to alter the offender's future behaviour. We're not hoping to make them a better person. We are simply saying, you've committed a wrong, so now you will suffer in proportion to that. Since we've moved away from the death penalty, retribution is now based on the idea that each offence should have a set tariff. So if you think, for example, the Lee Rigby killers, we know that one of the killers received life sentence whole life, so he will die in prison, and the other Lee Rigby killer got life with a tariff of 45 years. So the tariff is the minimum amount of time that he will spend in prison. And the reason, of course, that they got slightly different life sentences is the idea that it's in proportion to the offence. Obviously, the judgment of whether a punishment is appropriately severe can vary greatly across cultures, individuals, lots of people still critical of the life sentence that we have for murder. There are some people that would like the death penalty back, but it is very old-fashioned. We've moved away from this concept really now. We have a look at our second aim, deterrence. You can see from the slide here there are two types of deterrence: individual deterrence and general deterrence. Deterrence is the theory that fear of punishment influences people to obey laws. And if we look at individual deterrence to begin with, it's based on the theory that criminals engage in a rational thought process prior to committing a crime, and that if they know that the punishment they will receive outweighs any benefits from the crime, they will choose not to commit it. Or another way of looking at it is, if something not very nice happens to you, you receive a particular punishment, you didn't like it, That's going to put you off committing the same offence again because you don't want to receive the punishment again. But you can see that the effectiveness of this is undermined really by reoffending statistics. So 55% of our adult prisoners reoffend within 2 years of release, and 70% of our young offenders who've been given a custodial sentence will reoffend within 2 years. So that certainly casts doubt on the fact that sentences provide individual deterrence, because clearly these reoffenders have not been deterred from committing offences again. The other type of deterrence that we have is general deterrence, and this is where we are making an example of the defendant to deter society from committing the same crime. So the idea is, if we publicise the fact that this defendant did such a thing and we've given him this punishment and it's incredibly harsh, people are going to see that on the news and think, oh, I better not commit that offence. And that's the idea of general deterrence. There are some places in the world that use general deterrence still in quite a draconian fashion, where you've got people, if for example they were to steal a melon in a market, they might have their hands chopped off. That might potentially provide some individual deterrence because the offender wants to keep his other hand, but it also will provide general deterrence in theory, because other people in the market are going to see this horrific thing happen, and that's going to put them off committing the same offence. And there are places in the world where women are stoned to death publicly for committing adultery, for instance. And again, it's that idea of general deterrence, showing that society denunciating a particular type of action. General deterrence obviously conflicts with retribution, because retribution is all about the punishment should be in proportion to the offence, whereas general deterrence, you want it to be quite harsh in order to deter other people. Another problem with deterrence generally is that it's based on the idea that criminals are thinking rationally before they commit a crime, and that they are actively weighing up what might happen to them. And we know that lots of crimes are crimes of passion. They are committed in the heat of the moment, or they might be very opportunistic. In those instances, your defendant is not going to be thinking through what might potentially happen. So the value of deterrence generally, I think, is a little bit doubtful. If we look at our next aim then, incapacitation, the word incapacitate means to remove someone's ability to do something. So incapacitation means that the offender is made incapable of reoffending. They're not physically able to reoffend. And the ultimate method, of course, of incapacitation is the death penalty, because if you kill somebody, they're not able to do anything again. I mentioned before, in some other places in the world, they might cut off a thief's hands. That's a form of incapacitation as well, because if you remove someone's hands, they are incapable of stealing. Obviously, we've moved away from the death penalty. So in this country, we have minimum sentences for persistent offenders, which are protecting the public from the offender. So prison sentences are the main way that we incapacitate offenders in this country. But there are other ways that we incapacitate as well. So if you think about electronic tagging, that's often attached to a curfew. So we will make an offender incapable of committing offences at night by giving them a curfew and ensuring that they stick to that by putting a tag on them, and an alarm will sound if they are breaking that curfew. So they're incapable of going to particular areas or at particular times. Driving bans could be permanent or temporary, but whilst you are under a driving ban, that is going to incapacitate you from driving offences. Community sentences, where we might be making someone do community service, or what used to be known as community service, that's incapacitating them in the short term. because obviously whilst the person is picking up litter or cleaning up graffiti, they are not able to commit offences at that time. And the big benefit of incapacitation is that you are protecting the public, which is surely a really good aim of sentencing. And John Stuart Mill articulated this principle in his book On Liberty, where he said, quote, "The only purpose for which power can be rightfully exercised over any member of a civilised community against his will is to prevent harm to others." And that's known as the harm principle. So incapacitation, very good aim of sentencing because it's protecting the public and it's preventing harm to others. Our next aim of sentencing then is rehabilitation. And rehabilitation is a forward-looking aim because we are aiming to reform the offender, rehabilitate him back into society. And unlike retribution, this aims to alter future behaviour, and it's hoping to reduce crime in the future. The idea of rehabilitation really came to the fore with the development of community sentences, when we started realising that actually punishment isn't going to reduce future crime levels. The way we're going to reduce future crime levels is if we can rehabilitate individuals. And this is particularly important when we're sentencing young offenders, because if we get a young offender early and we can rehabilitate them, then that's going to impact many years ahead of them in their lives. It's going to really alter future crime levels. Rehabilitation uses individualised sentences. So these are tailored to the needs of the offender. So, for example, for rehabilitation, the defendant might be sentenced to a community sentence that requires them to have drug treatment, mental health treatment, alcohol treatment. It might require them to participate in particular courses that are going to help them, say, with reading and writing, which might prevent them from committing crime if they can get a better job. So these sentences are individualised. They are tailored to that individual, which is completely different to retribution having a set tariff, because with a set tariff, you're not looking really at all at that particular defendant, at that defendant's needs. You're simply going, you've committed X crime, the sentence for that is this. So rehabilitation has become much more important in recent years, really strong focus on this. The Offender Rehabilitation Act from 2014 says that rehabilitative supervision and mentoring support has to occur for 12 months upon release from custody for all offenders who are serving less than 2 years. So this idea that if people have been in prison, when they get out of it, we want to help try and support them to rehabilitate back into society so they don't reoffend. So dealing with those reoffending rates we looked at with deterrence. And our final aim of sentencing is reparation. And reparation is a bit like the word repay, and this aims to compensate the victim of crime. So the defendant may be ordered to pay a sum of money to a victim, or they might be ordered to make a restitution. And a restitution means that they're ordered to return stolen property to its rightful owner. And a lot of the time, restitution is very important to the victim, because whilst compensation is okay, if an item has sentimental value, if, for example, it's an engagement ring or something like that, you don't necessarily want compensation, you want that actual ring back. So restitution, quite important. Reparation can also happen sometimes, and I think you've got to be quite a brave victim here, but victims may want to speak to the defendant and tell them the impact that that defendant has had on their life, and that can be a form of reparation. And reparation can be made to society as a whole if they're cleaning graffiti in the street, for instance, or litter picking. And there is a duty now to make a reparation order.